Is your expectation not legitimate?
In incorporating international law principles into our jurisprudence through PIL, the Supreme Court made use of the doctrines of legitimate expectation and harmonious construction. What are these doctrines? The answer to these questions is what we will be dealing with today. When and how can the court interfere? When the administrative authority has the power to fulfill the expectation. In the Hindustan Development Corporation case, the court took the view that a case of substantive legitimate expectation would arise when a body, by representation or by past practice, aroused expectation which it would be within its powers to fulfill. The court could interfere only if the decision taken by the authority was arbitrary, unreasonable, or not taken in the public interest. If it is established that a legitimate expectation has been improperly denied on the application of the above principles, the question of giving opportunity can arise if failure of justice is shown. The court must follow an objective method by which the decision-making authority is given the full range of choice which the legislature is proved to have intended. If the decision is reached fairly and objectively, it cannot be interfered with on the ground of procedural fairness. In MP Oil Extraction versus State of MP 97, the Supreme Court considered the question again. In that case, it was held that the state's policy to extend renewal of an agreement to selected industries which came to be located in Madhya Pradesh on invitation of the state as against other local industries was not arbitrary, and the said selected industries had a legitimate expectation of renewal under renewed claims which should be given effect to according to past practice unless there was any special reason not to adhere to the practice. When the second instance when a court can interfere is when legislation changes the policy and there can be no plea of legitimate expectation. It is against administrative policy only. In Madras City Wine Merchants Association versus State of Tamil Nadu 94, the rules relating to renewal of liquor license were statutorily altered by repealing existing rules. It was held that the repeal being the result of a change of policy by legislation on the principle of non-arbitrariness, it was not, legitimate expectation was not invocable. When does legitimate expectation not apply? In Ram Pravesh Singh and others versus State of Bihar and others, the Supreme Court held, 2006, the Supreme Court held that public interest, policy change, the conduct of the expectant, or any other valid or bona fide reason given by the decision maker may be sufficient to negativate the legitimate expectation. Now let us see what that any other valid reason could be. Contrary to law. If the expectation of the claimant is contrary to law or any statutory enactment, such an expectation cannot be said to be a legitimate expectation. So it would be ignorance of law that cannot be excused. For instance, a cinema theatre cannot carry on shows when it doesn't have a license. The Supreme Court dealt with the case Ved Gupta versus Apsara Theatres in 83, where a person was managing a theatre without a license in contravention of the order passed by the district magistrate. Talking about the doctrine of legitimate expectation, the court observed the writ petitioner could not have any legitimate expectation that they will be allowed to run this theatre without a license in violation of the law. Unsuccessful applicant. If the application for receiving a license or other equivalent documents is rejected on the grounds of not fulfilling any requirements for the same, the unsuccessful applicant cannot invoke the doctrine of legitimate expectation. In this regard, the Andhra Pradesh High Court in Government of Andhra Pradesh versus HEH, the Nizam of Hyderabad, 92, said, in India, the theory of legitimate expectation applies only to a fair hearing, which the petitioner had before his application was rejected, or to a final favorable order in pursuance of a similar intermediate order. Non-appointment for bona fide reasons. In Union Territory of Chandigarh versus Dilbagh Singh and others, the Supreme Court said that qualified or selected candidates had no indefeasible right to be appointed to a civil post and hence cannot claim a right to be heard before the appointment is rejected for valid reasons. Now, another reason could be where there is a statutory contract. As per the observations of the Supreme Court in Assistant Excise Commissioner versus Isaac Peter, 94, the doctrine of legitimate expectation cannot be invoked to modify or vary the express terms of a contract, more so if it is statutory in nature.
Legislation changes the policy, then there can be no plea of legitimate expectation. It is against administrative policy only. In Madras City Wine Merchants Association versus State of Tamil Nadu 94, the rules relating to renewal of liquor licenses were statutorily altered by repealing existing rules. It was held that the repeal being the result of a change in policy by legislation, the principle of non-arbitrariness was not invocable. When it is ultra vires the power and jurisdiction of the authority, then there can be no plea of legitimate expectation. In Hira Tikku versus Union Territory Chandigarh, administration of Union Territory of Chandigarh allotted plots under a development scheme and received full and part payment. However, subsequently it was found that a portion of the area of land in question was already declared reserved under the Forest Act. Besides, it fell within the periphery of 900 meters from the Air Force and thus infringed the Aircraft Act. Consequently, the administration failed to deliver this land to the people who were allotted that land. Supreme Court observed that the administration would not be liable when there is mistaken advice or when representation is found to be infringing the statute. Recently, courts in England have taken an approach balancing the ultra-vires representation and public interest or awarding compensation to aggrieved parties of such representation. In Stretch versus UK, the applicant was granted a lease for 22 years by an authority that could not do so. The applicant was acknowledged at the advanced stage of negotiations. Even though the Court of Appeal agreed the lease should not have been extended, it also stated that it was unreasonable for those authorities to be able to take advantage of their mistake. In Monet Ispat and Energy Limited versus Union of India, the petitioners argued against the state of Jharkhand of backing out from a memorandum of understanding which granted mining rights to certain companies because it was in violation of a previous government order. Both promissory estoppel and legitimate expectation doctrines were used to back their claim. However, the court held that both doctrines cannot be used to enforce a promise, assurance, or representation which is against the law, public interest, and public policy. The Government of India, upon examination of the proposals, rejected them on the ground that subject area was under reservation and not available for exploitation by private parties.
Where there exist overriding considerations on grounds of public interest. In Hindustan Development Corporation, the court found that it would be justified in refusing relief in overriding public interest, though the doctrine is found applicable to the case and the applicant has been put to hardship on account of breach of the doctrine. It was reiterated in the case of Bannari Amman Sugars Limited versus CTO, again the Supreme Court, that guarding legitimate expectation should not come at the cost of non-fulfillment of an overriding public interest. In PTR Exports Madras versus Union of India, 96, the doctrine of legitimate expectation has no role to play when the appropriate authority is empowered to take a decision under an executive policy or the law itself, and that the government is not restricted from evolving new policy on account of legitimate expectation as and when required in public interest. This is laid down in that case. Similarly, in Howrah Municipal Corporation versus Ganges Rope Company, 97, it had been held that no right can be claimed on the basis of legitimate expectation when it is contrary to statutory provisions which have been enforced in public interest. This was not 97, it was a 2003 case. In Madras City Wine Merchants Association, which we have already discussed, the doctrine of legitimate expectation was held to become inoperative where there was a change in public policy or in public interest, and has been reaffirmed in some of the aforementioned decisions. In Shriji Sales Corporation versus Union of India, 97, the Supreme Court observed that once public interest is accepted as a superior equity which can override individual equity, the principle would be applicable even in cases where a period has been indicated for operation of the promise. If there is a supervening public equity, the government would be allowed to change its stand and has the power to withdraw from representation made by it, which induced persons to take certain steps which may have gone adverse to the interests of such persons on account of such withdrawal.